Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the recommendations of the 2016 SEC Government Business Forum on Small Business Capital Formation, a forum I had the honor of participating in and attending. Over the next couple of LawCasts in this series, I will be summarizing the 15 recommendations of the forum in order of priority. The first one is that, as recommended by the SEC Advisory Committee on Small and Emerging Companies related to the definition of an accredited investor, the SEC should: 1, maintain the monetary thresholds for accredited investor currently in place, and 2, expand the categories of qualification for accredited investor status based on various types of sophistication, such as education or experience or training, including but not limited to persons with FINRA licenses, CPA or CFA designations, or persons that hold management positions within issuing companies. Second, the definition of smaller reporting company and non-accelerated filer should be revised to be increased to include an issuer with a public float of less than 250 million or with annual revenues of less than 100 million, excluding large accelerated filers. Also, to extend the period of exemption from compliance with Sarbanes-Oxley Section 404B for an additional 5 years for pre-revenue or low-revenue companies after they cease to be an emerging growth company. The third recommendation is for the SEC to lead a joint effort with the NASAA and FINRA to implement a private placement broker category, including developing a workable timeline and plan to regulate and allow for finders and limited intermediary registration, regulation, and exemptions from any registration. I think this topic is vitally important. The issue of finders has been at the forefront of small business capital formation during the 20+ years that I have been practicing securities law. The topic is often explored by regulators, including the SEC Advisory Committee on Small and Emerging Companies and the American Bar Association. Despite all these efforts, it has been very hard to gain any traction in this area. Part of the reason is that it would take a joint effort by FINRA, the NASAA, and both the divisions of corporate finance and trading and markets within the SEC. This area needs attention. The fact is that thousands of people act as unlicensed finders, an activity that, although it remains illegal, is commonplace in the industry. In other words, by failing to address and regulate finders in a workable and meaningful fashion, the SEC and regulators perpetuate an unregulated fringe industry that attracts bad actors equally with the good and results in improper activities such as misrepresentation in the fundraising process equally with the honest efforts. However, practitioners, including myself, remain committed to effecting changes, including by providing regulators with reasoned recommendations. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.